We do plan on getting started relatively soon. I know we're late, but just when the hearing officer is ready, just want folks to know that. Also, good morning.
Madam Chair, is there a new Wi-Fi password?
We are not sure that the Wi-Fi is working. Trying to figure it out. I might suggest using your phones for now.
Thank you.
All right, if we can get started again, we'll resume where we left off yesterday. Is
Hearing
Dr.
officer, I apologize for objecting. Prior to starting today, I'm being required to make a formal objection on the record.
Go ahead.
Thank you. Should I come to the podium?
You can speak from there as long as the court reporter can hear you, but I think she prefers for you to come up. Yeah. You can identify yourself for the record. We got a new court reporter. Okay.
Many of you can find that title.
Good morning, hearing officer and board members. My name is Dory Richards, and I represent the National Nuclear Security Administration, Department of Energy in this proceeding. After consultation with the Department of Justice, we must lodge our formal objection to the board continuing in this proceeding. In light of the city's action passing Monday's resolution, we concur and give heed to the city attorney's office interpretation that the resolution passed immediately under the principles of meaningful variation, and the board lacks authority to continue at this time. Because we serve in a position of public trust to serve the entire nation's interest, we will continue to engage in the proceeding at this time to protect the interests of the United States and ensuring its important energy security and national security missions. But by participating in this proceeding, the federal parties do not concede the legality of the proceeding or any actions that might come from the proceeding. Thank you.
Thank you very much. Your objection is noted.
And Mr. Hearing Officer, the Kirtland Air Force Base joins in the objection.
Okay. Thank you, Mr. Willard.
Sir, the United States Air Force joins as well.
Ms. Kofke, thank you. Your objection is noted. Do we have Dr. Bilsback and Dr. Clark online?
Mr. Hearing Officer, we do.
Okay, let's see if they can appear. Mr. Domenici, you can pick up where you left off with Dr. Clark. I think you completed your examination of Dr. Bilsback.
Yes, sir. I did.
All right. Dr. Clark, can you hear us?
Yes, I can.
Okay, you should be coming online here in a moment. There you are. And I'll just remind you that you remain under oath.
Yes, sir.
Good morning, Dr. Clark.
Good morning.
I take it you made it home okay and might have had a long evening.
It was quite long. Thank you for asking.
So sorry you had to go through that, sir. Based on your resume, is it fair to say that you've been deposed and testified in court proceedings multiple times?
Yes, sir.
And in those proceedings, you've testified as an expert witness?
Yes, sir.
And when you testify in those proceedings, are your opinions to a reasonable degree of scientific certainty?
Yes, sir.
And are your opinions in this case to a reasonable degree of scientific certainty?
Where they can be, yes.
And are there instances where they are not to that level of certainty?
Since this is a policy matter, I am certain about the science. The policy is, and doing it to a reasonable degree of certainty, yes.
So can you give us a distinction of just generally what you consider the policy parts of your testimony as compared to the, say, scientific parts?
The scientific part is related specifically to the use of the risk assessment paradigm and the development of the policy falls from that. So identifying the most appropriate data sources to use in this analysis, and then trying to meet the policy goal of a de minimis risk to the community and reducing the risk overall to Bernalillo County.
So were you involved in drafting the original draft rule that was presented in November of 2022?
Yes, I was.
And have you been involved in the changes to that draft, at least up to version 4?
Yes.
And then I think if I understood from yesterday, you haven't provided input for versions 5 or 6. Is that correct understanding?
No, I believe I put some, I had some input into it. I was asked to review some of the materials.
I noticed that in version 6, the use of metadata was changed from the prior version, in that at one point the regulation required 1 year of actual on-site data. And in what I'll call version 6, the most current version, there's an alternative, which is 5 years of, I'll call it airport data, or 5 years of data from a reliable source. Would that be accurate?
That's accurate, yes. And that was updated to be more consistent with guidance from EPA related to the modeling standards.
Okay.
And ultimately, sir, it was a concession to make sure that for projects that were closer to Albuquerque, they could use the available data. And the issue related, as we discussed yesterday, further away from the airport, which is the primary source of the metadata, the less frequently people are collecting data, or there may not be any data out there. So it was a concession to the permittees that it wasn't overly burdensome. The idea of the 1 year of on-site data is, if they have this specific data, then it should be incorporated to give us the most accurate assessment of where the contaminants are moving from the site.
Okay. And prior to assisting in drafting this particular rule, have you been involved in drafting any rules that might fall under the classification of environmental justice?
Objection
this is-
irrelevant.
It goes to his experience and qualifications.
Overruled. You may continue.
Not on environmental justice. I've put in input in to other cities related to health risk and air contaminants. But this is the first EJ.
And when you say cities, are you referring to something like this board, the proposing regulations that would be used for either a state or a specific geographic location?
Yeah, it was specific to the city of Santa Clarita, working with their building and development department, looking at how to revitalize a particular area and the air quality issues that were associated with that, and the health risk from the movement of materials up there.
But it hasn't been with the board that sets air regulations, correct?
Correct.
And at any time in your work on this, have you identified even approximately, or not even, just approximately, how many permitted facilities would be impacted if the regulation, and I'll use version 4 because I know you're familiar with that. Do you have an idea how many facilities would be impacted by that regulation?
I was not tasked with identifying all of those sources, or all those who would be affected by that. So it was proposing, how do we reduce the health impacts in the communities affected?
Do you have an idea of the types of facilities that would be affected?
Asked and answered. Dr. Clark said he didn't review, that he wasn't tasked with reviewing sources.
Objection sustained.
In your review of the notices of intent, have you identified some of the sources or permitted activities that will be affected by this rule?
Objection, same objection.
Sustained.
Judge, the NOIs have specific facilities that are addressed.
Well, to the extent that you can answer it, Dr. Clark, go ahead.
I have not sought to identify all the types of facilities that are being affected by this.
Do you, did you try to identify at any point whether Bernalillo County, in terms of industrial activity, is comparable to any other jurisdictions that you've worked in?
Objection, relevance.
Overruled. Go ahead.
Can you restate that question, sir?
Yes, I asked, did you try to identify whether in terms of industrial activity, Bernalillo County is similar to other jurisdictions that you've worked in?
And no, I haven't attempted to match Bernalillo against or Albuquerque or Bernalillo County against other air base, and I consider this kind of a clearly identifiable, unique situation for this area. So making a comparison of one basin to another with their activities wouldn't really affect the process of creating the goal of the regulation, which is trying to reduce the impacts from polluters on the community.
Have you identified the major mobile source pollution sources in Bernalillo County?
Well, the major sources would be cars and trucks. So any of the vehicles moving through the city and on the major highways.
I note in your testimony, you indicate that I-25 goes through Bernalillo County, correct?
Correct. And I'm sorry, sir, just not to interrupt you, but I do want to make a fine point on this. The other source, mobile source, would clearly be the rail train, the rail traffic moving through the area. So those would be the three major mobile sources.
Okay, sure, thank you. So you identified I-25, and then I noted you identified Route 66. Can you explain why you identified Route 66?
I identified major arteries within the area.
Are you aware that I-40, Interstate 40, goes through Albuquerque on a east-west interstate?
I missed that one. Yes, then there would be another artery there.
Well, no, that's in traffic terminology, an interstate's not considered an artery, is it?
My specialty is not traffic, so I don't know about that definition. You know, the city clearly has a number of different vehicular openings and arteries and highways and freeways. And yes, there's a lot of vehicle traffic going through the area. That doesn't affect what the intent of this whole regulation is about, which is about the stationary sources and mitigating the impacts from those stationary sources where your clients are asking for permission to emit materials. And the intent of this regulation is to minimize the health impacts from those emissions.
And I think you indicated you've testified in New Mexico once before at a state air permitting proceeding. Is that correct?
Correct.
What other air permitting proceedings have you testified in addition to that one in New Mexico?
That's the one that comes to mind. I don't remember the last time I've talked about air quality in this kind of setting.
And have you prepared air permits on behalf of clients in any of the jurisdictions you work in?
Yes, I was
Objection
prepared.
asked and answered. That was asked and answered yesterday.
Sustained.
How many air permits have you issued out of this jurisdiction, Bernalillo County, City of Albuquerque? Have you reviewed as part of your work for this project?
Objection. He already answered that one as well, Judge Sanchez. He's only worked on one air permitting in New Mexico.
No, I'm asking about what he reviewed to prepare for this testimony.
Go ahead. Overruled.
I reviewed, I think it was either 3 or 4 different permits of various types within Bernalillo County.
What types?
There was an asphalt plant. There was, I believe one was for I think it was a backup generator, and I'm unclear on the other 2. There had been a lot of materials that have been reviewed.
Certainly. Do you have your testimony available, sir?
Jeff,
I'm going to ask you to refer to it. I'll ask you some questions from it.
okay.
Let me find it here. Now, I know you withdrew and replaced your original testimony, correct?
Correct.
And your testimony yesterday was that basically you were just moving things around. Is that fair enough? Fair statement?
That's a fair assessment, yes.
Content stayed more or less the same.
Yes.
Okay. I'm sorry, Mr. Hearing Officer. It's going to take me 1 second to find that revised version. Oh my gosh. Give me one. I apologize. Can I take 1 minute? Should I locate this?
Can I have just a 5-minute break to use the restroom?
That's perfect.
Yes, that's fine. We'll
Thank you.
sit tight.
A lot of those questions that you asked.
Vance, what is the docket number for Dr. Clark? For his resume and testimony? 180. Okay. And I saw the corrected report is 203. Yeah.
Mr. Hearing Officer, I've spoken with Mr. Domenici, and before he proceeds, I have a short couple of questions on the revised testimony.
You will follow Mr. Domenici once he's done.
I'm going to object to an exhibit, however, here. So
You want to be called out of order before Mr. Domenici continues? Is that what you're asking?
Before Mr. Domenici proceeds with his questioning concerning the revised testimony.
Okay. All right. And all right.
Yeah, I'm happy to check that.
203.
We haven't taken any.
Some decorum.
We haven't taken roll. We've all recognized that it's a quorum on video. But,
I asked Antoinette before if we needed to take a roll, and she said, as long as we.
I mean, we just do it every time.
I have my notes all over mine. I can't find.
She's on the way. Sorry, I was just thinking about that.
You have to take a roll just for purposes of the record right now.
I'm giving you-
Go ahead if you'd like to do it before the witness starts.
Real quick, just for the written record. Yes.
Yes, that's fine.
Apologies. Just for the written record, it was requested that we take a quorum. I know we have a video record as well, so you can see that the quorum has been here the whole time, but we will do that just to have it on. Ms. Esther Mijo, would you please call the roll for quorum? If she's there. Yes.
Yes.
Give me one moment, please. Member Armijo,
Here.
Member Kalman,
Here.
Member Eberline,
Here.
Member Galuski,
Here.
Member Lewis. Absent. Vice Chair Richards, Chair Paul,
Present. I believe Vice Chair Richards is on her way. So with 5 members present, we have a quorum.
Dr. Clark back on?
Yes.
Mr. Mullenberg, you had some questions out of order at this time?
Yes, Mr. Hearing Officer. My name is Dalva Mullenberg. I'm counsel for the New Mexico Mining Association and the New Mexico Chamber of Commerce. Dr. Clark, I have a couple of questions for you regarding the corrected Exhibit 2 that was filed with a pleading petitioner's second notice of errata, document 203. So my question is, you've indicated that the corrected exhibit more or less contains the same testimony as in your original direct testimony, which I believe was Exhibit 2 in docket 180. But I'm having a little trouble tracking some of the added underlined language in corrected Exhibit 2 with the stricken language, and I'm concerned that this may be a little more than a reorganization. Did you prepare petitioner's corrected Exhibit 2, which is your red line strikeout direct testimony?
Yes, I prepared that, and then counsel assisted me with redlining.
Thank you. And did you add any new language or testimony in petitioner's corrected Exhibit 2 that was not contained in your originally filed written direct testimony?
As I'm looking at it on page 13, there may be a change in the language related to, in the top paragraph, the use of 0.1 for the hazard index.
And that was, I would agree, as a passage that I had trouble identifying in the original direct testimony. So at this point, Mr. Hearing Officer, I would move to strike petitioner's corrected Exhibit 2 in docket number 203 to the extent it contains new direct testimony that was not filed in a timely manner in accordance with the procedural orders for this proceeding for filing of direct testimony, and also would move to strike any oral testimony that's been given that incorporates the newly filed written direct testimony.
Judge Sanchez, if I may respond. First of all, Dr. Clark's amended testimony was filed the same day as his rebuttal testimony. So if anything else, it aligns with what is in his rebuttal. It aligns with the amendments that were proposed jointly by petitioners, Dr. Sofia Martinez and Manuel Criollo and Pablo Abisleta back when the NOIs were originally filed. And I think it might even align with some previous versions of the rule. The change to the hazard index was an error in the version 4 amendment to the rule. That, and my final point is just that the board's rules allow and encourage including all relevant evidence and testimony in these processes.
And Mr. Hearing Officer, if that's the case, it's simply misleading and deceptive to file new testimony under a notice of errata. If petitioners wish to do so, they should have moved and clearly identified that to the other parties so they could respond. If in fact, Dr. Clark's testimony of this nature is in his rebuttal testimony. And if it's proper rebuttal, then there would be no harm in striking that new testimony as it's in this exhibit.
Judge Sanchez,
Motion to strike is denied.
Then, Mr. Hearing Officer, I move for a continuance of this hearing for a week so that the other parties can properly review and prepare rebuttal to the new but untimely filed written direct testimony.
That's denied as well.
Thank you.
Mr. Domenici, you may continue.
Dr. Clark, so sir, could you put that document up? We're going to share the screen. So I'm looking at page 2 of Dr. Clark's testimony. Actually, Dr. Clark, you're not a medical toxicologist, correct?
Correct.
And have you been certified by any organization as a toxicologist?
No, I have not been certified by those voluntary organizations. There's no mandate or requirement in any state that I am aware of or federally to have a certification to be a toxicologist.
And your PhD is in public health, if I understand correctly.
It is from the School of Public Health and Environmental Health Sciences with an emphasis on air pollution. And I had a sub-emphasis of toxicology.
Thank you. Now I'd ask to turn to page 4, please.
Yes.
Okay, so Doctor, you describe your scope of work, and on page 4, I want to point you to the part that says, it starts out with the word currently. It's about the 7th line down.
Yes.
So it says currently a small proportion of census blocks within the county carry the greatest amount of pollution burden. And then you give an example of disproportionate harm. Now, and you, if I understand correctly, you're saying that data comes from the EPA in its EJ screen tool.
Yes. So as I referenced yesterday, any individual can download the data from EJ screen as a CSV file. And within that file contains the raw data that EPA used to go ahead and calculate percentiles, which is typically what is displayed in the EJ screen. But from that, I was able to identify the block groups and then the associated value for each of the block groups. What in this case, it was diesel particulate matter.
And then you say a small proportion of census blocks within the county carry the greatest amount of the pollution burden. And you give an example of related to diesel particulate matter, if I understand that correctly. Is that right?
Correct. Correct.
And so I added those census blocks together. You started with 114, then 46, then 23. Let me see here. I might have missed one there. 114, 46, 23, So that's not really a small proportion. That's close to half, or at least over a third, are having that diesel particulate matter at a level that you felt was significant. Would that be correct?
So I'm just gonna help a little bit on this because you can't add these together. It's kind of like doing particulate measurements. Okay, if you look at the first line, it says 114 had in excess of 0.55 micrograms per meter cubed. Within that 114 is included the 46 that had values above 0.684, and then the 23 that were above 0.76. So it's, in this case, it's not additive. These are subsets of that first group.
Okay.
So
And-
if you look at the raw number, 114 out of 467 had values in excess of 0.55.
And did you place those on a map?
No, I have not mapped them.
Do you know one way or another if those are proximate to the two interstates that go through Albuquerque?
I have not, I can't tell you that.
Then look, if you can turn to page 5. In the documents reviewed, and I know this may go to the question Mr. Molenberg had, you list versions 1 through 4 in the first bullet.
Yes.
And this was filed after version 5 had actually been presented by the petitioners and the UNM Law Clinic. Did you, I understand maybe you were just trying to repeat what you had in your first version, but did you review version 5, which was filed the same day that this testimony, that the uncorrected version of this testimony was filed?
Yes, I had reviewed version 5.
Okay.
And you are correct. I was trying to keep it because I was just correcting and adding that, as we already discussed, that one issue at the 0.1. I was trying to make this consistent.
Okay. And then you reviewed the original petition to amend?
Yes. I have reviewed in the course of preparation of all of this. These are the items that I've reviewed. Yes.
Okay. So I don't see in here that you reviewed part 41. When you reviewed those several permits that you identified, did you cross-reference part 41 while you were reviewing them? If you recall.
I do not recall.
Then if we look on page 6, my question here is, first of all, the line 3 talks about requiring a health risk analysis when seeking to locate a polluting source in or within 1 mile of an overburdened community.
Yes.
Was that, did you suggest that language for the rule, the 1 mile part?
My original suggestion had been to do the concurrent or the surrounding block groups or census tracts. And it was actually a suggestion from your side that wanted a fixed radius from any particular source. And after considering that, I considered the variables along the way and determined that 1 mile would be the most appropriate radius for any given site.
When you say your side, are you referring specifically to my consultants or generally to, I want to say maybe opponents to the rule?
I would say opponents of the rule. I can't remember if it was Kirkland or the university or somebody else.
Okay. Then if you go down 3 more lines, this is something I want to track through to the rule, is the word source
Yes,
or modify the source.
yes.
Is the source different than the facility?
The source would be, yes, it would be different from the facility. This is this is being tracked back to a modification for a particular permitted operation.
And when you talk about modifying the source in such a way that will lead to a net emissions increase. So
Yes.
let's focus on modification if we can. So that would be from that source if there's a modification. And what do you mean by net emissions increase?
So if the existing permit had a particular mass amount that was allowable under that permit, if bringing in the new permit or new sort, modifying it would change that to increase the amount of emissions, that's the net increase that I'm talking about, the pre and post.
And so that would focus on the mass of emissions.
Yes, when there's evidence of an increase in the mass and the modification, which is currently how most of these permits, it's been my experience because the majority of these comes from engineers and they want to look at mass amounts rather than the health risk associated with the emissions. When there is an increase in the total amount coming out, that is clearly a modification which could have, in my view, in the public health world, will have health impacts. It's all back to the dose is the poison. So the more emissions there are, the more likely you are to have health impacts.
I just want to be clear in terms of the rule, you wouldn't be expecting the permit applicant or the regulator to look beyond whether or not there's a mass increase for purposes of triggering this provision.
For the net increase, yes, for modification.
Okay. And then when the screening of that source that's the basis of the modification, when you're screening that, does the screening look at the additional mass or the net emissions increase, or does it, we're having a little audio visual here, or does it look at the total emissions from that facility?
So the screening had been designed to look at primarily new sources going in and saying, if you are below this value, then you're at a de minimis risk. I think the question that you're trying to get to with that is, can that be applied for the net increase along the way? And I think that's something that the board can consider as to whether they want to restrict that just to the net increase or to the total amount.
Well, I agree the board can consider that. I'm just trying to understand when in the draft of the rule is the intent for modifications or a modification of a source that is in doing the screening to model the net, the emissions increase or the total?
The intent is to look at the total.
But I think you said that the board could look at screening just the net increase, correct?
I did say that, and I was speculating as to what the board would and would not do. But
yeah,
you were asking me what the intent of this was.
Yeah.
And the intent is to look at the total emissions from each one of the sources and assess whether that has a negative health consequence associated with it.
but this rule does not apply to currently permitted sources unless they seek a modification, correct?
Correct.
And this is more in terms of the modeling tools that you've proposed. Isn't it true that the net increase could be modeled more or less the same as the total emissions could? You could still use the same tools, you just have different inputs.
Correct.
Then I think this may be the first time, I may be wrong, but if you go down a little bit further, it's a long paragraph, but this is the first time I see the word unmitigated, at least in my review. It's about 10 lines down in your analysis section.
Yes, where it says, unless the applicant's unmitigated air dispersion modeling demonstrates the sources emissions will not impact the overburdened community.
And I thought your testimony yesterday indicated the reason or the basis for that opinion of yours was that controls may fail or they may not work as well over time. Is that a good summary, or would you be able to restate your basis for using unmitigated?
No, that's an accurate assessment.
Do you have any studies that you rely on for that statement?
There's a good host of literature. I'm not recalling it right now. I mean, I can certainly go look for the board and pull that out, but there's clearly evidence out there that over time, if control technology is not maintained, that you will see a decrease in its effectiveness. And that's why there's an operations and maintenance plan typically in these kind of things. But my experience with large sources of volatile organics like refineries shows that if these maintenance operations are not maintained, that you will have instances of decreasing efficiency in the control technology.
So you understand that we're not, or do you know if are there any refineries that are subject to this rule?
I'm not aware that there's a refinery in Bernalillo County. I was using that as an example of a process or an operation that has multiple control technologies in place that are known over time to fail.
Did you do any analysis of any sources in Bernalillo County to come up with this, or as a basis for this opinion?
This is a generally accepted principle in the field, and it's clearly understood that there are issues with maintaining control technology. There's a whole industry based on trying to keep the control technology in place and operational. So no, I haven't done a specific analysis within Bernalillo County.
And are you aware that the use of an unmitigated emissions could increase the mitigated emission amount by several orders of magnitude for certain operations?
That question was a little unclear. Can you restate it for me?
Are you aware that the difference between mitigated and unmitigated emissions can be several orders of magnitude for certain sources?
Yes, exactly. And that's the concern. That's why I'm bringing up the unmitigated versus the mitigated emissions. If you are controlling hazardous air pollutants, to say something particularly toxic, that needs a control technology with 99.9997% control, if that technology does not, if it's not up to snuff, yes, it can be orders of magnitude difference between the unmitigated and the mitigated emissions. The whole intent on that is that EHD has the range, it can consider the range of emissions from any given source, and also work with the permittee to identify additional controls or operational procedures, whatever reporting that needs to go on. There's a feedback loop that could be set up so that they understand what the range of emissions will be and prioritize the future analysis of what's going on at that site.
So you're saying this should be data used by EHD for monitoring and oversight?
They should be considering it in there, yes. So if there's an upset condition, let's make an example up. We've got an operation, you put it in place, it's operating for a number of years, and then somebody is starting to do some fence line monitoring, and they see that there's clearly an excess amount of emissions coming into that area. They can then tie it back to that particular site to say, hey, look, we got a problem with your emissions coming out here. One, show us your operation and maintenance plan and sampling going along the way so we can see when your controls failed.
Are you familiar with the denial criteria in the draft proposed regulation?
I have reviewed it a couple of times. Yes, somewhat familiar with it.
Isn't it true that the unmitigated, using the unmitigated emissions can act, and then running it through a model can actually be a basis for denial, not just monitoring and oversight?
Can you point it out to me?
Sure.
Where that is listed?
Yeah, let me get to it. That would be page 23.
Okay.
I'm looking at the December 1st, 2023 first amended proposed changes. And let me find the docket number, Mr. Hearing Officer. I think we had the docket number for this as 200.
Okay, I see it.
So for purposes of denial, not just monitoring or oversight, the unmitigated air dispersion modeling is what you used, correct?
Correct.
So it really isn't, there's no discretion for EHD at that point. That is a model run. And then under this rule, there's an automatic permit denial based on unmitigated emissions, correct?
No, that's not the way I read that. It says the department may. It does not say shall or will. It's may.
May what?
May deny.
Okay, well, if you look at paragraph 2 above, or maybe you're looking at 3.
I was looking at 3.
Okay, if you could look at 2, please, sir.
Yes, it says when the toxic hazard index exceeds 1, a value of 1 or more, which ever is low as long as the unmitigated air dispersion modeling demonstrates air pollution emissions from the source will be dispersed to the overburdened community.
So that does not give any discretion, DHD, or the applicant.
It shouldn't. So if if you're going to increase the hazard index above 1, that's one of the criteria. It says this is not acceptable.
I'm not looking at the hazard index. I'm looking at the dispersion, which requires use of unmitigated unmitigated, not
Correct.
the result, but you're inputting an unmitigated emission. Let's say it's a new facility that has expensive emission controls or mitigation. You're proposing in this rule that those be ignored and all of that investment not be considered, and the unmitigated emissions from that source are what determines if the permits must be denied, correct?
In that one case, yes.
That's not accepted. That's not widely accepted in the industry, is it?
I don't think it is. I think what we're trying to do here is protect the health of Bernalillo County.
Well, aren't other jurisdictions trying to protect the health when they allow the use of mitigated emissions?
Yes, they are attempting to do that. We're trying to improve the air quality and the health of the community. And this is clearly a manner in which we can get direct results for this.
Have you done any analysis of whether the difference in the amount of facilities that could be permitted or that could actually reach this hazard index if they used mitigated emissions as opposed to unmitigated?
No, I have not done that analysis because that would really be dependent upon the conditions of each site. So you're asking for a hypothetical analysis of something that hasn't been put into effect yet.
Right. This whole concept about using unmitigated emissions is hypothetical as far as how it would impact industry because it's not commonly used, right?
That's correct. It is used in California when we're looking at CEQA analyses, so emissions from large projects. So the mitigated and unmitigated are considered in the analysis.
Does the use of unmitigated imply that the permit holder and the regulator should not be trusted to be able to collectively maintain the mitigated emissions?
I'm not making any assertion about the reliability of either of those parties. What I'm saying is that one should consider in the analysis, what is the worst case scenario and what's the most likely scenario?
Even if the worst, of course, even if the worst case scenario is orders of magnitude from the, yes, right?
Yes, yeah. If you are doing a public health assessment of what the impacts of something are going to be, it is reasonable and generally accepted. You want to look at all the conditions that are out there. You don't always choose the rosy scenario that the emission controls are always working.
But the entire basis of the current permit system in Bernalillo County is that there is enforcement and inspection and self-reporting to assure that permit mitigation measures are maintained and are effective. Would you agree with that?
There is that assumption, and has been pointed out by other counsel related to the staffing at EHD. If they don't have a large enough staff to inspect every site frequently, then there is going to be a data gap there. And all that this program is asking is that you consider what the unmitigated would be so that you then have a way to prioritize in your inspections which sites need to be evaluated.
I don't agree with you, sir. You just read that the unmitigated is used to deny permits.
You can deny,
not-
you can, I don't agree with you, but that's okay. This is hashing this out.
Shall deny means shall deny, pretty much, doesn't it?
Yes.
And then just to follow up on that slightly, so when you run the mitigated or unmitigated emissions through the model, you are trying to, you're basically modeling 70 years of exposure to 1 million people to see what the cancer risk is.
Correct. That's the standard protocol.
So you've already got, well, let me just ask, do you know if the life of any of the facilities in Bernalillo County is expected to be 70 years?
I can't tell you that. What I can tell you is this approach is generally accepted in public health and in the risk analysis world. So yes, there are some assumptions that we're making that operations will be continuous along the way, but that's a reasonable assumption.
And even if I understood your testimony, even for portable sources that are allowed to relocate for 1 year or I think it's 364 days, under this rule, they would be required to model, take their unmitigated emissions, run them through a model that utilizes a 70-year exposure to the unmitigated emissions for a plant that's been relocated for less than 1 year, correct?
Correct.
And if I understood, that was based on, at least partially based on your statement that for a portable source, they could move a block away and then operate for another year, and then another year, and another year, correct?
Correct.
Did you review the requirements for approval of locating a portable source in part 41?
I've read all of part 41. I'm not recalling right now. I mean, if you want to pull something up, we can go through it.
Well, when you made your statements about that it could move, I think first you said a block and then you said a foot. I don't know if you really meant a foot, but did you mean more like a block or?
I wasn't meaning any particular distance. I was just saying that because it's portable, it can be moved from one location to the next. And I was using a hypothetical saying that it had moved some distance along the way. Whatever the part 41 requirement is, we can go into that. It does, what I'm saying is that for a portable piece of equipment, the emissions still need to be considered. And back to your question about the 70 years, this is a standard approach, which is asking what are the health impacts associated with the emissions from this portable system, so that we take into account all of the sources that will be contributing to the health impacts to the community.
But if the source actually only operates for 1 year at that location, shuts down, goes into standby or moves miles away, you're modeling 70 years of emissions from that source that has been operating 364 days, correct?
So I think you're conflating the number here. I'm asking you, we are asking for operational emissions for any given year. So for a year of exposure, and it is standard protocol to take the output of that, which is the concentration within the community, and to assess whether there is an incremental increase in the cancer risk or the hazard index. So whether the operation is there 1 year or 70 years, it is a secondary matter. The issue is, what are the impacts from the emissions at that facility?
So you're saying when the emissions are input into your model for a portable source, you would only input emissions for 1 year?
That's what you're doing for every source. You're doing an annualized emission rate in the permit and then comparing that against exposures for 70 years. Yes, there's an assumption that this source would be there for a period of time and that this exposure would be continuous.
And with respect to unmitigated, I'm going to double check here, but I don't think there's a definition of unmitigated. Let me just double check. So there's no definition of unmitigated. Let me ask this, if the permit restricts the hours of operation, when you use unmitigated emissions, do you accept that restriction on hours? Or is that something you more or less do away with when you're looking at unmitigated?
The unmitigated is supposed to reflect raw emissions without controls. So what when doing the annualized emissions, the modeling typically incorporates an hourly factor or an operational scheme to account for the hours that it's not in operation.
So using the term unmitigated, you would still consider the hours of operation limitations in the permit?
I'm not limiting the hours on there. It was definitely one of the things to consider in the model. It'd be incorporated into it.
There's no definition of unmitigated. We're asking permittees to model that and regulators to deny permits based on it. I want to be crystal clear. What is unmitigated?
I think I gave you the definition already. Unmitigated is the annualized emissions without emission control.
And
assuming that there is a failure of emission controls.
Okay, so hours of operation would not be considered an emission control under your description there.
Correct. The hours of operation are incorporated into the modeling run itself, but that's not part of the mitigation.
Okay. If you could turn to page 8, please.
Yes.
I'm sorry, no, this is, I'm going back to his testimony, which was 203. So while he's getting that, I want to have one follow-up on the portable sources. Do you understand, sir, that portable sources are either mandated or strongly preferred as a way to crush and reuse construction materials rather than trucking them away to be recycled and then trucking them back?
So I understand. Well, you're talking about a very specific operation. So you're talking about a pug mill to crush all this stuff, generate dust, and have that. Then you're saving a step along the way. Yes, I understand what they are.
And then that material is used on the construction site.
Yes.
And
So
it's a recycling process.
On the site, you are now generating particulate matter through that crushing operation, and you're also generating diesel exhaust from the typical operation of pug mill along the way. And without adequate emission controls, you're going to be re-entraining dust, which will then move off-site, depending on the size of the site, and will potentially impact the local area. Or it will impact along the way. Now, the question in there is, what is the composite material for the road base or whatever you're digging up? And there's very good evidence out there in the literature related to what goes into concrete and some of the toxic materials that are it's been used in the past to incorporate hazardous materials in there to bind them so that they don't enter the environment. But yes, those operations have their own unique hazardous compounds that can be generated there.
Are you familiar? Do you understand that a portable source has to be permitted first as a stationary source
Yes.
with controls?
Yes, I understand.
And then there's
what we're asking for is that there's a better understanding of what the potential range of emissions are for each of those sources.
and then there's a relocation permit process
Okay.
in order to move that stationary source. Do you understand that?
I understand that from you. Yes.
And do you understand that there has to be modeling done of that stationary source that's been moved or relocated based on the circumstances of the input and output of that particular location? Basically, job-specific modeling is required.
Yes. And this will ask that in that modeling, you go ahead, instead of just using a mass value, you go ahead and actually assess the potential health impacts within the local community.
You have to go through the entire health impact analysis process, correct?
Yes, I believe you would. So that would be if you can, unless you can demonstrate through the screening process that the emissions will be so low as to not impact anyone.
And I think you were asked a couple of questions about both the expense of the new permit process, the pre-application process, and the amount of time. You understand that there is, the way the rule is set up in the pre-application, the HEI study must be presented to the Environmental Health Department, and then there can be a hearing held as to whether their determination is correct. So there's a hearing process in the pre-application process itself. Are you familiar with that?
That sounds familiar. It's not, I'm not coming to mind right away. Can you point out to me where that's written in there?
Let me ask you, I'll point it out, but let me ask you, when you stated that someone could get approval with under the proposed rule, and I think you said 3 to 6 months, were you including the hearing process and the appeal process for that hearing when you gave that testimony yesterday?
The question had been how long it would take, if I remember correctly, the question was how long would it take, do I assume it would take to get through the technical part of it? So no, I did not consider the hearing process.
If you could look at page, if we could put up, I hate to go back and forth, but page 20 of the regulation. I'm sorry, I couldn't hear you, sir. Okay, 200. $20, please. No, we don't have, that's not the right exhibit up there, sir. It's, you had it before that, no, that's not it.
Mr.
Mr.
Domenici,
Hearing Officer.
Do you mind if I take a bathroom break while you find this?
Sure. Well, it's up
Thank
to
you.
the officer, but
Let's go and take a 10, 15-minute break.
15 minutes would be great. Thank you, sir.
Okay, great.
You can ask him how much longer he's got. He said an hour yesterday. He said he's way over an hour.
Maybe I'll walk over and ask him. He's ready to go. Commissioners have one more, and then the law clinic has the 2 doctors pending. By my count,
so that's what I'm trying to get to.
And I think is that exhibit 17. If this is the one filed by us, at least. Oh, this is petition. Okay, sorry.
Well, let's see, First Amendment proposed change filed
Yeah.
jointly, but I guess I got
guess
it.
this is the one that Maslin
I
submitted,
got
though,
it.
so I'm sorry, that
So I'm
one's-
not sure how I'll be able to find this now.
Okay.
So I might end up using yours
Okay.
if I can't get them.
That's the problem.
All right, let's see if we can get started. I think Chair Paul does have one matter to take up at this time.
Just really quick, just another reminder about decorum, folks. I know there's a lot of important issues we're discussing today, but I hope we can all continue to do so in a respectful manner, understanding that people's, care about this from many perspectives and that we're here to listen. So yeah, please be respectful. Thank you.
All right, Mr. Domenici, you may continue.
Okay. Dr. Clark, I think we're going to try to share screen so we don't, or split the screen so we don't have to go back and forth.
Okay.
Can you see
All right.
the two different documents on your screen?
I don't know how to, hang on a sec. I need to change the view so that it's just on the speaker. Okay, there we go. I see it now.
Okay, so on one of these is your testimony and the other is the proposed rule. So that's how I'm going to distinguish them.
Which
So,
one's the testimony? The one on the
it's-
right?
Yes, sir.
Okay, thank you.
And then the other one, so sir, if you could do the proposed rule to page 20. So that's the left-hand document.
Yes.
Okay, and if you could scroll up just a little, or the other way, I'm sorry, scroll down. I apologize. So
Yes.
that's perfect. So Dr. Clark, does this refresh your recollection that there is a public hearing process required on the applicant's HEEI report?
Yes.
And do you have an idea of how long it takes to conduct, to do the scheduling and arrangements and then conduct that public hearing?
No, I do not.
And at the bottom of subpart 2, so this would be G2, it says at the public hearing, community testimony, community-based participatory research data, and community air monitoring data shall be given the same weight as technical expertise provided by the department and the applicant. I know that there have been some other witnesses discuss that. Are you providing any opinions on on that section of the rule?
No.
I think you said no. I'm not sure.
Correct. I said no.
Okay.
Let me turn my volume up. Sorry. Mr. Domenici, is that better?
Yes, sir. Thank you very much.
Okay.
So just to finish up on the portable source issue, if we could turn to page 28 on the left-hand document.
Yes.
So those are the exemptions. I think we're on the wrong document. Okay, so is that page 28? I'm looking at. So that starts the exemption section of the rule. You see that, sir?
I do.
And then it carries over to the next page. Under E, so this would be 15E, activities excluded. Stops. It's right at the very top of that page. Thank you. Activities excluded from modifications as provided by 20.11.41.4 U 1 through 4. Are you familiar? I wouldn't expect you to be, but are you familiar with that section of no, I lost it, of part 41?
No, I'm not very familiar with that.
So that's in the definition section. That's a definition. And that is for the term modify or modification or modify. And in the language of that, it indicates, it describes what is a modification. And it says, unless previously established as a portable stationary source subject to specific permit conditions. And then it says, but does not include. So do you know one way or another if that use of that citation of that definition is meant to exclude portable sources like that entire section U does, or only to exclude certain items or certain parts of that?
I don't know.
And just sort of a final couple of points on portable source. Obviously, they're important to my clients. So do you understand that there could be specifications for the amount of time that concrete must be poured in from when it's generated in order to meet various construction specifications?
Yes.
Do you understand that if this regulation goes through without changes, there is a likelihood that the City of Albuquerque Airport could not continue to maintain its runways or create new runways because that would require a portable source, potentially in an overburdened community?
Objection, Mr. Domenici is testifying.
If you can answer the question, go ahead, Dr. Clark.
I can't answer the question.
I noticed one place in your testimony, you indicated that, and let me see if I can find it here. So this is on this is at the very end of your testimony, your summary or your conclusion, which is on page 32. That would be the document on the right. And in that, the third line from the bottom, you indicate that a rule like the proposed HEEI is reasonable and implementable and will protect the health and welfare of Bernalillo County as a whole. So I just want to focus on that word welfare. Does the welfare, in your use of that word, does that include having a modern functional airport?
Mr. Domenici, I don't have an answer to that.
Well, that's your term. So you say it
So
will protect
health
the
and
health.
Objection asked and answered.
Sustained.
Okay. Does the welfare of Bernalillo County include having reliable, functional medical facilities?
Mr. Domenici, there's nothing in this rule that would prohibit the functioning of a hospital. All it's asking is that the sources of hazardous air pollutants and criteria pollutants in the county assess what the impacts are from their emissions on the community. So there's nothing in there that would prohibit smart folks over at the university being able to tailor their control technology to make sure they're reducing the amount of hazardous air pollutants coming off the site.
They have to reduce it to below the median, correct?
Objection asked and answered.
Sustained.
you indicate there's nothing preventing them. Is that your testimony generally? There's nothing preventing any source in Bernalillo County from meeting these regulations?
Same objection.
Go ahead.
I'm sorry, Your Honor, and does that?
Go
mean I
ahead
should-
and answer. I'm
Are you-
overruling the objection.
Yeah, there's no constraint in there from preventing an applicant for a permit to come up with technology controls or systems to reduce emissions to prevent them from operating. All it's going to require is more thought about what they're doing and how they control the emissions from their site and prevent it from going into the community.
But if I understood earlier, they must model the unmitigated emissions without regard to the controls in order to make it through the denial section, correct?
So I'm glad you brought that up. I wanted to clarify that in that particular section where it's talking about the denial on point 2, it says denial if it's above 1.0. I did not specify the mitigated or unmitigated. And the second sentence in that line talks about showing that it actually gets to the impacted community in the unmitigated state. So my intent when we were writing this was that it was looking at the emissions, controlled emissions coming out, and we're calculating the hazard index associated with this. The second line in that about the unmitigated is related to showing that it's going to get to the community. And I apologize for not being clearer on my answer earlier.
So the modeling would be able, the person, the applicant or whoever's reviewing the model, they could review mitigated emissions as the
Yes.
input to the model.
Yes. So if you look at, if we go back to docket, the docket on the left, 203 on page 23, when I was reviewing this again on point 2, shall deny if the new or modified source increases the air toxics hazard index in any overburdened community within 1 mile radius above the county mean or median, whichever is more conservative, and increase of chronic or acute by a value of 1.0, whichever is lower, as long as the unmitigated demonstrates air sources dispersed into the community. So the intent of this was to say it is the mitigated hazard index that we're dealing with, and that the unmitigated modeling would demonstrate how far it gets out there.
I'll probably have to have a permit modeler discuss that later in testimony. I'm not quite sure I understand but is that the case wherever you use the word unmitigated in here, it is meant to apply to the dispersion, not the emissions?
Yeah, it's the dispersion model. I want them to, the intent of the regulation is to model, and this is not a difficult thing, it's a quick change in the source terms along the way. The range of the plume coming out, and from that, you determine the ground level concentrations of each of the chemicals of concern, the items that are being emitted, and then you do the health risk analysis. So it's the annualized ground level concentration times the unit risk, inhalation unit risk factor, to come up with what the potential cancer risk is in any given receptor. And remember, the receptors are humans. It's not just some geographic location. And then the short term, the annualized concentration for the hazard index, as well as short term evaluations to determine as you brought up, there's issues related to the production schedule, we'll call it, the operational schedule of any particular source. And it is very important to consider how the peaks of exposure can be occurring across a year.
Okay.
So if, for example, if you have a portable site which operates only at night, we want to know what the peak exposures would be during that time, particularly if it's near residences that it'd be residences that folks would be at home during the night and would be exposed to the materials that are being released from the facility.
I think that's going to shorten my questions a little bit anyways. Thank you for that clarification.
Oh, you're welcome.
So if you could look on page 17, if you could scroll to page 17 on the right-hand document.
Yes, sir.
Or page 18, I'm sorry. That uses that same phrase again, unmitigated air dispersion modeling. That's, I think you might have to scroll up just a little more, or the other way down.
Should just start giving them 10 minutes.
Is that the same definition or same understanding as you just described?
I'm sorry, can you point, can somebody point to the
so
line?
it's-
I'm sorry,
it's
it's already
two
been a
lines,
long day.
2 lines from the bottom, right there.
Two lines. Unmitigated air dispersion modeling of HAPs expected to be released from the source. Yes. So that would be the condition where the control technology fails.
So that's different than the use of that same exact phrase in the denial section?
No, I think that's exactly the same. I'm looking at, the question is, what are the potential, so in that denial, in part 2, the part that you pointed out was the unmitigated air dispersion is, it's the same definition. It is uncontrolled emissions from the site, a failure of the technology. What is the maximum amount that can be expected to come out along the way? We're asking for an evaluation of, just include those concentrations along the way so we know the range of potential exposures. And if your control technology is working properly, then we should be receiving the lower dose or the lower concentration, which we calculated either as an HI or a cancer risk.
Have you, when you reviewed the several permits that you described, I'm sure you looked at the modeling data, at least glanced at it. Would that be fair to say?
Yeah, it'd be fair to say that I glanced at it. So, you know, there was one particular one that looked like it was an asphalt plant, and they had gone ahead and they had their requirements in there. And I noticed that they had already speciated all of the HAPs coming out. So in that application, they had already done that. First essential step was not just give you total VOCs or reactive organic gases or total organic gases being emitted from the site, but gotten down to the level of providing a speciation of emissions of each one of the HAPs that was associated with the process. Yes.
If I understand correctly, you're proposing that a different model would be used for purposes of the HEEI report, or is it the same modeling methodology?
It's the same modeling methodology. All that we're asking for is a finer grid to make a better assessment of what the emissions impacts are going to be within the community. So the use of air mod and the source terms is all pretty standard along the way. And it's just that the input terms for the model, the actual source terms, we have that order of preference along the way. Use data from existing facilities or operations that have the same kind of equipment that you're proposing to put in, and either use the continuous emission or fence line monitoring associated with it, and then move all the way down in order of preference. And finally, if there's no other choice, then make a justification why AP 42 would be appropriate for it.
And what does it take to reduce the grid down to the level you did in terms of on the modeling side? What does that require?
For most of the modeling systems, it's essentially a couple of point and click options to go ahead and decide how far what area the modeling grid would cover and what the spacing would be between it. So it's not a difficult operation along the way. It does increase a little bit of the interpretation, the modeling time, the modeling run itself. But given today's computing power, it's not going to significantly alter the amount of time that would it take to run the model.
And you don't need to gather more data? The applicant would not need to provide more input data?
No, as long as they have the source terms predefined, which they're going to have to do anyway. What am I doing? What am I putting out? Now, instead of just doing as total VOCs, give a speciation of everything that's coming out. You can run it as, you can run the model either as total organics coming out and then partition it based upon the fraction of each compound in the source at the ground level, which is a very frequently used method. Or if you want to set it up so that each chemical comes out at a specific rate, you can do that. And then you let the model run and you've got your output, which shows you the ground level concentration of each one, either the total organics, which then it's a little math to go ahead and separate that out, or you can do it, like I said, the second way where you go ahead and have separate outputs.
I'm going to try to wrap up here, Mr. Hearing Officer. Can we, a couple of questions on page 24.
Of which document, sir?
Your testimony. So that's the other document.
Okay. The one to the right?
Yeah.
Okay.
I'm speaking to you, but I'm also talking to the gentleman running the documents.
Thank you. Appreciate it.
So on page 24, right above the health risk analysis, you indicate the intent is to be health protective and provide a method to allow businesses to operate in an economically feasible fashion, but the first consideration must be health.
Yes.
Is that one of those more policy type statements, or is that something you are indicating to a degree of scientific certainty?
It's more of a policy statement.
And then right above that, it talks about emission rates multiplying factor.
Yes.
Is that a protocol you adopted from some other location, or is this something you've modified or created yourself?
I'm trying to remember if it is from another jurisdiction or not, but the essence of it is that we're trying to get site-specific information rather than taking generic information and then assuming facts not present to come up with an emission rate. Ultimately, Mr. Domenici, the idea is that we want to be health protective. We want to be as site-specific as possible to give all parties involved with this the best information to deal with the issues associated with any particular source along the way. So using the best available data related to what the source is, what it's going to put out, the range of emissions that are associated with it. So this, avoiding these emission rates multiplying factors, it means that we're trying to get to a very specific level of information related to each site so that all parties have equal information they could deal with.
And then that emission rates multiplying factor is required for the inputs into the models to do the cancer and the health index screening.
Yes, so the dispersion model creates a matrix of exposure concentrations. Those exposure concentrations are used in health risk analysis to either calculate the cancer risk or to calculate the hazard index. And this is the common language we want to be using. Chemicals have different impacts on individuals along the way. And by using the risk analysis matrix, using this quantitative risk approach, we have an opportunity to take a broad view of all pollution sources in the county and say, how are we going to prioritize what's going on out here? How do we protect the residents within this small community or the associated communities within a mile of each one of the sources here? So the quantitative approach is very, there's an efficiency in it, trying to make sure that we all have the same language along the way.
Let me just try to wrap up here. There's been some discussion about the public process, stakeholder meetings. Were you aware that I requested a meeting to discuss portable sources with your council? Did that information make it to you?
No, I was not aware of that.
That's all I have. Thank you.
Thank you.
Thank you.
Thank you, Dr. Clark.
We will continue the cross-examination of both Dr. Billsback and Dr. Clark. Mr. Rose and
Judge
Mr. Domenici have been very comprehensive as far as their question is concerned, very thorough. I would just ask remaining parties who are cross-examining to please avoid repetition. If there is repetition, I would expect to hear an objection from the New Mexico Environmental Department, Ms. Locke or Mr. Jens.
Judge Sanchez, can we raise a procedural issue? Just to inform you, our two witnesses have time limitations today at 4 and 5 p.m. That's Dr. Johnston and Dr. Unseld. And so I don't know how long Cross is planning to continue for Dr. Billsback and Dr. Clark, but if it's going to be a while, if there's any possibility of perhaps getting them first, that would be helpful.
Okay, we'll see what kind of headway we can make.
Thank
Mr.
you.
Mullenberg?
Thank you, Mr. Hearing Officer. Good morning, Dr. Clark. My name is Dalva Mullenberg. We spoke briefly before, but I'm counsel to the New Mexico Mining Association and the New Mexico Chamber of Commerce. I have a few questions for you, but not too technical. In your testimony, you compare various exposure and risk criteria within Bernalillo County with other counties nationwide and within the state. Do you recall that generally?
You're muted.
Oh, I'm sorry. Should I get closer to the?
I apologize. Sorry about that. Can you point out where in the testimony?
Okay, sure. On page, I'm specifically referring to pages 4 and 7 of your direct testimony.
Is that docket number 180?
I'm actually referring to docket 203, although I believe this testimony is the same in both.
Yeah, the corrected report.
Yes.
Thank you.
Okay, sir, I'm at that point. Yes.
Okay. So, for example, toward the bottom of page 4, you make a statement that EJ indexes from EJ screen for Bernalillo County show that the whole of the county is in the top 25% of counties in the United States or New Mexico for, and then it goes on to talk about various criteria. Do you see that?
Yes, that's on page 7.
And for that comparison, you're including all counties in the United States and all counties in New Mexico. Is that correct?
Correct. This is the EJ report, which you can generate by going to EJ screen and then capturing the county and then doing the comparison from that.
Okay. Thank you, Dr. Clark. And above that, you talk about certain information derived apparently from the EJ screen tool relating to diesel particulate matter exposure and certain cancer risks and the like. Do you see that?
I do.
Okay. So would you agree with me that emissions and resulting air quality impacts from things like diesel truck traffic tend to be higher in urban or metropolitan areas versus rural areas?
That really depends on the proximity of the location to the roadway. So as you move further away from the roadway, the concentrations of particulate matters decrease. Now that's assuming that the primary source or the only source of the diesel particulate matter is from heavy duty trucks or automobiles, something associated with that. If you've got other things in the area like emergency backup generators or some kind of boiler that uses diesel, then you'd have an associated site. But yes, generally, urban environments have higher concentrations. And as you get closer to a freeway, I noticed that what I had been talking about Route 66 and that Route 66, I think is also called Interstate 40. So as you get closer to those junctions, you would see higher concentrations of diesel particulate matter.
And the traffic that generates those emissions as well as stationary sources tend to be more concentrated in urban or metropolitan areas as compared to rural areas, correct?
Correct. And then if Amazon was to come in, just give an example, Amazon was to come in and put a distribution center in there, you would see that there'd be higher diesel particulate rates around that particular distribution facility because it's just where the sources are going in and out.
But for your comparisons, you've included all counties in the nation and the state, as we've talked about earlier. Do you know how many counties in New Mexico have areas defined as metropolitan areas?
No, I don't.
Would you be surprised if the answer was 3?
Objection asked and answered.
Sustained.
And when you look at all counties in the nation, obviously there are a lot of counties that are rural and sparsely populated. Would you agree with that?
I would.
Wouldn't a fairer comparison in terms of looking at whether Bernalillo County is disproportionately impacted in terms of air quality impacts be to compare Albuquerque with other metropolitan areas?
One could do that, but the analysis that I was performing there is a summary from US EPA in their EJ screen. So comparing all counties across the nation, I've got an evaluation, or they provide an evaluation there. And then within the state of New Mexico, they also provide the same thing. So I think the data that I presented from EJ screen is a fair evaluation of air quality impacts.
A fair evaluation of air quality impacts when compared with all counties in the nation or the state, whether urbanized or rural, right?
Correct.
Right. Dr. Clark, you've testified about the permit denial criteria. Do you recall that?
Yes.
Does the mandatory permit denial criteria in the proposed rule contain any exception if the applicant can show that there is no available control technology or process change that could reduce emissions to the specified risk levels?
I don't know if there's an exclusion in there for that. I
You
don't
don't
think there
recall?
is. I don't recall, but that seems counterintuitive. If there's no control technology and you're proposing to put this out there and you're emitting toxic contaminants, you are willingly putting out large quantities of toxic air contaminants in an unabated fashion.
Well, you say large quantities, but quantities, I think in this context is perhaps a little off. You're just putting out whatever quantity it is that would result in the modeling showing an exceedance of the risk level, and that could be a very small quantity, right?
Depending on the toxic chemical, yes. So getting back to the purpose of the rule is to look in this risk paradigm, this quantitative risk analysis paradigm, to say, how do we reduce the overall burden within these communities? So if in your hypothetical, if there's no control technology and it is emitting some amount, I will say large, we can agree or disagree on the amount, put some unabated amount and it results in an elevated risk, that from a public health policy perspective seems like an unwise endeavor. So the regulatory agency should have, I think, part of their requirements is to ensure public health, imminent or whatever the language is in there in part 41. But their purpose in this matter is to protect public health. They have an obligation to the public to ensure that they have done everything they can to maintain or improve public health.
And when in that answer you referred to elevated risk levels, you're referring to the risk levels that petitioners have chosen to place in the proposed rule language. Is that right?
Correct. So there is a background risk that is provided, not background, it is the risk from the stationary sources that EPA evaluated within the context of EJ screen. And it may not incorporate all the sources that are in the county. So we're starting with the available data. Available data says that the county averaged somewhere around 25 in a million. So that's the 50th percentile for cancer risk. It is changing the paradigm to say we don't want the risk to increase, and we really don't want the risk to increase in neighborhoods that are already impacted by these pollutants coming from various sources.
And the selection of those risk levels, would you agree, is a policy choice as opposed to a scientific choice?
I think they go hand in hand. I think science informs policy. And it's clear that as the risk increases or the hazard index increases, you have more health effects. And from a public health perspective, you're going to see more disease, whether that is cancer or whether that is symptomatology like shortness of breath or the other factors. You know, typically people talk about asthma, experience of asthma in communities with high particulate matter or irritation of upper respiratory systems from ozone or other oxidizing chemicals. So yes, the two inform each other along the way.
Thank you, Dr. Clark. That's all I have.
Thanks.
Department of Energy, Ms. Richards, unless NTES is
Can
going
I get
first.
one more break? I'm sorry, I drink a lot of water and I just need 5 minutes to
Okay,
go to the
we
bathroom.
we'll sit tight here while you take a few minutes, a couple of minutes.
I apologize, hearing officer. I believe UNM is before us, and I know that they have said they prepared questions.
I go down my line, which would be NTES and U.S. Department of Energy, then UNM.
I apologize again, hearing officer, but we've always been last. The outline that you provided at the beginning of the hearing and previously was all the permittee parties, then Sandia Labs. It was UNM, Sandia Labs.
I'll look at my scheduling order, and I have no problem rearranging if everybody agrees.
I just think my questions are less than theirs, so
That's
it'll
fine.
be faster.
We'll have Mr. Calderon or Ms. Navarrete next.
That's fine. Thank you.
Once Dr. Clark returns. All right, Dr. Clark is back. Mr. Calderon?
Good morning, Dr. Clark.
You're muted, Dr. Clark.
I apologize. I keep doing that. Good morning.
Not a problem.
I'm going to try to be brief and cover some sections that may have not been covered already. Isn't it true that petitioner's proposal requires an applicant to analyze pediatric asthma prevalence as a health indicator?
I believe it does, yes.
And isn't it true that pediatric asthma prevalence is not available data on EJ screen?
It's not, but it's available through the county. I think it's is it the ISIS? They have their own data set. So there is publicly available information related to the prevalence of pediatric asthma.
But with respect to EJ screen, that's not available data on EJ screen.
Objection.
Sustained.
Are you aware of a rule in effect in the United States that requires dispersion modeling of unmitigated emissions?
Mr. Domenici asked that question.
I believe it was a different question.
Go ahead, doctor, if you can answer the question.
I'm sorry, can you state it again? I got lost there.
Yes. Are you aware of a rule in effect in the United States requiring dispersion modeling of unmitigated emissions?
In California, we do look at the mitigated and unmitigated emissions. In particular, we use the CAPCOA, C-A-P-C-O-A system called CAL-EMOD, C-A-L-E-E-M-O-D. And in the CEQA analysis, we go ahead and look at what the mitigated and unmitigated emissions from any particular project are. And in that is included the criteria pollutants and greenhouse gases along the way. So yes, under CEQA, we go ahead and evaluate those mitigated and unmitigated emissions.
And those three examples you gave, is that correct?
No, that was one example.
One example, and that one
Yeah.
example related to unmitigated emissions, is that part of a EJ type rule?
Yeah, actually, it's not specific to environmental justice, but it is considered. So we've seen references to Cal E-Screen. I think it was Cal E-Screen 4 from some of the other experts along the way here. And in this evaluation, the modeling has been updated to include that as part of the reporting requirements along the way. When you generate this report for any particular project, part of that consideration are some of the economic factors along the way. So yes, this is to look at large projects, well, large being anything over a particular dollar amount, and to see what the influence is within a particular area. And yes, exactly, that one of the considerations is mitigated and unmitigated emissions.
I believe CEQA relates to conservation. Is that correct?
No, it's the California Environmental Quality Act. So in this, there are, don't quote me, I know I'm in a public hearing, but there are essentially 9 components that they need to be.
Just a reminder, you're under oath.
I know, but I'm saying I'm doing this extemporaneously. So if I don't have the exact number right, I apologize. But it looks at issues such as air quality, the presence of hazardous waste in the air, the geological considerations, what are the tribal considerations along the way, greenhouse gas emissions, traffic concerns, and there are a few other elements along the way.
And isn't it true that under CEQA, unmitigated does not mean uncontrolled emissions?
No, that as far as I understand, the definition is, in particular, the emissions are related to, there are control technologies that you can put in place. In fact, if you look at, if I was to do an analysis looking at diesel particulate or emissions from generators on site, there's an opportunity to put in the control technology, which would be essentially what we're talking about, the mitigated versus the unmitigated. So whether we're using a tier 1 to tier 4 final type of generator, and are you going to add additional controls along the way?
So is my understanding of your testimony correct that under CEQA, it's true that in evaluating unmitigated impacts, you are allowed to consider use of controls as required by law?
Yes, you can consider controls in the mitigated section.
Did you just say in the mitigated section?
Yes, so you start out the evaluation assuming that you have some level of technology in place. So let's just use the example of, we're looking at
Let me ask you a different question, okay? Because I think your answer, you didn't quite answer my question. So let me ask it again. Isn't it true that in evaluating unmitigated impacts under CEQA, you're allowed to consider use of controls?
You can consider controls, but that goes into the mitigated section. So if the technology,
I'm talking about unmitigated.
Objection asked and answered.
Clarify your question, Mr. Calderon,
Yes,
and please do not interrupt the witness.
Understood.
Thank you.
I'm referring to the unmitigated impacts section of CEQA. So when you're doing an unmitigated impacts analysis under CEQA, you're allowed to consider the use of controls as permitted or required by law.
If you assume controls, you have to designate what those controls are. So it gives you the assumption in this is essentially that there's a whole host of, a lot of this deals with pre-construction emissions along the way. And if we look at the control technology on equipment that's going to be out there during the construction phase, because it's also expensive, you're not going to have the highest level of control in place. So we want a baseline assessment of what is essentially available currently out there for the construction to come up with what the unmitigated emissions would be. And then you can kind of step in to say, well, I need to put these additional controls in place to reduce this below the significant threshold values. These are what are typically are driving this. There are significant threshold values related to construction and operational emissions in California. So if you can do this in an unmitigated fashion and stay below the significance thresholds, then it is generally considered appropriate to move forward with that.
Isn't it true that a standard permit under Part 41 could require monitoring and testing to ensure pollution controls are working as designed?
Objection. Dr. Clark already told Mr. Domenici he hadn't reviewed Part 41.
I have not completed my question.
Let
Mr.
him-
James
let-
has
that-
time
that's
and
fine.
again
Let him-
objected in the middle of questions, and it
let
does
him-
not make a good record either.
Let him complete his question, Mr. Jans, before the objections made.
Understood.
Thank you.
Go ahead.
Dr. Clark, isn't it true that a standard permit under Part 41 could require monitoring and testing to ensure pollution controls are working as designed? And therefore, should the department determine that additional protections are warranted, that they have the authority to implement monitoring and testing requirements under existing rules?
Same objection as I had before.
I'm going to sustain the objection that this is repetition.
It's a different question, but okay. Dr. Clark, what communities have you worked with that require continuous fence line monitoring?
I'm working with a community down in Torrance related to that. There is a refinery there that's been there for decades. And when the new owner bought it, as part of legislation in California, they required continuous fence line monitoring and reporting.
And what was the
And
new
that-
legislation you referred to?
I believe it was South Coast Air Quality Management District Rule 1180, I believe was the rule. So for refineries, I know in particular in the South Coast Basin, I think that it's a statewide program requiring monitoring on the fence line of refineries. So these are high volume facilities putting out lots of emissions.
Are you aware of a rule in effect, other than the one it sounds like you just mentioned, in the United States that requires continuous fence line monitoring for all new stationary sources?
So there's California one. I'm not sure about other states. No.
And maybe I made an assumption. The rule you referred to just now in California out of South Coast, does that require continuous fence line monitoring for all new stationary sources?
It is specific to refineries.
Are you aware of a rule in effect in the United States requiring all sources to collect their own meteorological data?
No, I'm not. In the as I've expressed a number of times in this hearing, that requirement is to be consistent with the modeling guidance from US EPA, which says you can either use 1 year of on-site data or you can use regional data for a 5-year period.
And
so actually, just to put a fine point on this, I'm not being argumentative. There's an option there. You can either use the regional data, or if you have site-specific data that would show the different influence, you have the option to do that.
Yeah, and I had a question about the actual language that's included in the December 2023 proposal. It indicates that it would be required to provide 1 year of on-site meteorological data or the most recent 5 consecutive years of National Weather Service data quote, whichever reflects worst case scenario, correct?
Correct.
So the way this is written, an applicant would still need to provide 1 year of on-site data to determine which set of data is the worst case scenario, correct?
Can you point to the page so I can see that the language?
I've got exhibits, document 200, exhibit 17. Give me one sec, on page. Maybe your attorney can refer us.
Actually, I see it. It's on page 16. So the applicant shall collect 1 year of on-site meteorological and ambient data for use in air dispersion modeling, or the most recent 5 consecutive years of National Weather Service data, whichever reflects worst case scenario. I read that and I don't see that as a stricture that says you have to collect it. And if it's a wordsmithing thing, then and or in there, if the applicant can demonstrate that the 5 year is sufficient, then they should be able to go with that.
Okay, the concern is that, we only have what's written to go off of. So are you saying that that's not petitioner's proposal, what's included in version 6, only submitted a few days ago on December 1st, 2023?
Objection, asked and answered.
Overruled. Go ahead and answer.
So I am saying the way I read that, it says either 1 year of on-site or 5 years of met data.
So based on that statement that says whichever best reflects worst case scenario, doesn't that call for a comparison?
Yes, and if you don't have the data, then you can't make the comparison. Then it's incumbent on the applicant to go to EHD and say, I don't have on-site data, so I'm going to use the 5 year data.
So let's go ahead and utilize petitioner's most recent version of the proposal and apply it to a hypothetical, okay? It's my understanding that if a hospital is required to go through the process outlined in petitioner's proposal version 6, and then a boiler affecting the emergency department experiences failure, petitioner's proposal would require a 1 year hiatus on modifying the failed boiler due to a need to collect the necessary data to seek a permit to make it operational again. Is my understanding correct?
Yeah, your understanding is absolutely wrong. So
how does the hospital get, how does the hospital
Hold on,
address?
Mr. Calderon. I think he's going to continue with his answer, so please do not interrupt.
So it's reasonable to assume that the hospital, with all its resources, can go ahead and use the 5 year data collected already out there to represent the conditions that are there. And I don't see anything in this language that prohibits them from using that 5 year data. And all we want is the most recent data. The need for an on-site collection of data, I think I expressed this multiple times in my testimony, is particular to areas that are outside of the influence of the standard MET stations.
So prior to asking the hypothetical though, the question, what you were asked and what you testified to was that a comparison between the 1 year on-site data and the 5 year National Weather Service data had to be performed. So where are you reading in this rule version 6 that that's not required?
Mr. Hearing Officer, I'd like to object to this because the basis of the hypothetical is incorrect. The proposed rule explicitly accepts routine maintenance, repair, and replacement.
Go ahead and clarify, Mr. Calderon, your question.
I don't believe there's further clarification. What I'm trying to understand is where in this rule, based on that section referring to meteorological data, indicates that a hospital would not have to wait a year before proceeding with the permit process because there's a need to collect this data to proceed with the process according to this and compare it to 5 years of National Weather Service data to determine which is the worst case scenario. So my question to you, Dr. Clark, is where in this section indicates that this is a either or rather than you got to compare the two, which you already testified to?
I've already testified. Just look at the word or. A reasonable interpretation of this language is if you have the on-site data, you use it. If you don't, you use the 5-year data.
Okay, but you agree that there is the comparison that's called for based on the language that states whichever best reflects worst case scenario, correct?
Objection asked and answered.
Sustained.
Is diesel particulate matter an EPA listed HAP?
No, it's not. It's frequently listed in other states. And I know in particular, California lists it as a known human carcinogen. And as I expressed to everybody yesterday, that data or that evaluation by the Science Advisory Board was performed, I believe, or published in 1998. So US EPA has not determined that it's carcinogenic. They know it is. They just haven't come up with a unit risk factor.
And isn't it true that the most common sources of diesel particulate matter are diesel trucks and emergency generators?
Yes.
And diesel trucks are not regulated by the petitioner's proposal, correct?
Correct. And we're not asking them to regulate them.
And emergency generators are exempted and therefore not regulated by petitioner's proposal, correct?
Correct.
If a source emits only PM10 and PM2.5 and does not emit other pollutants, such as a cooling tower, for example, is there a screening value for this type of source included in the proposed rule?
Because it's particulate matter, that would fall under the Clean Air Act. So as long as those values don't increase the annual average of the 24-hour average above the NAAQS value, there's no screening. No, there's not a particular screening value. That defaults back to the essentially the framework for the new source review. So are these particles going to exacerbate the existing particulate matter issue in a particular area? So no, I didn't generate a screening value for those.
Okay. And that was intentional?
That was, I'm sorry, what was your question?
Was that intentional?
My focus was on the air toxins.
Is there a unit risk assessment for a source such as a cooling tower to show compliance with the 5 and 1 million permit denial criterion petitioner's proposal?
That would depend on what the constituents of the particulate matter are. So what kind of biocide is the hospital using that would be entrained inside the particulates that are going to be distributed in the community? Your a priori assumption about what constitutes a particle needs to be defined a little bit further related to what is inside of that particle. So if your biocide, they used to use arsenic, they used to use hexavalent chromium. I don't think you're doing that right now, but it's incumbent on the hospital to go ahead and identify what is going to be in that water that creates the particles. So if they can identify the compound, then there's a screening value in there.
So coming back to the question though, does petitioner's proposal include some sort of risk assessment threshold to show compliance with the 5 and 1 million permit denial criteria?
I'm sorry, say that again.
Does the petitioner's proposal include a risk assessment threshold to show compliance with the 5 and 1 million denial criteria?
Well, the 5 and 1 million is the threshold. So it was based upon the additional burden that placed in any given area. And as I demonstrated to everybody yesterday, that can be a 25% increase to a 16% increase based upon what EPA puts out as the cancer risk in the air. So the census block immediately west of the university has an associated cancer risk of 30 in a million. And half of that 30 in a million is formaldehyde coming from the university. So any kind of additional burden in that would clearly place it above the county average.
And I'm glad you brought that up. Isn't it true that 2/3 of the formaldehyde exposures in the block group that you referred to in your rebuttal are from secondary formations in the atmosphere?
I didn't dive into it that far to look at it. What I was looking at was air tox screen and their evaluation saying that in 2019, this is how they partition it. And this is what's coming up. So if it's a secondary formation related to emissions that not you personally, but you, the university, are having, then we need to understand how to control the source to reduce that. Because formaldehyde is a known human carcinogen, and controlling it at the source would be important.
My understanding is that the exposures that you refer to in that part of your testimony relate to a block group adjacent to the university. Is that correct?
Correct. It's just to the west of University Avenue.
And isn't it true that the block group that you're referring to now near UNM is located adjacent to Interstate 25?
I believe it is. And if you go to the source material on this, you will see that US EPA and air tox screen associates half of the risk with the university.
And when you were asked, though, about whether that 50% that you're referring to, when you were asked about 2/3 of that 50% stemming from a formaldehyde exposure stemming from secondary formations in the atmosphere, you indicated you didn't know, right?
Correct. I don't, this is whatever the secondary formation, we need to, it has been attributed by EPA back to the university as the primary source.
The Bay Area Quality Management District defines an essential public service as including a hospital or other medical emergency facility, correct?
I'm sorry, you said Bay Area Air
Correct.
Quality Management District?
Yes.
I would have to go back and look at their guidance. But I will take your word, that's what they define it as.
And the Bay Area rule definition of essential public service, you familiar with that definition used at the Bay Area?
No, I'm not.
Objection asked and answered.
Sustained.
The Bay Area rule definition of an essential public service does not expressly enumerate sterilization facilities as an essential public service, correct?
Objection asked and answered.
Sustained.
I
He said he's not,
respectfully disagree.
he said he's not familiar with that reg offhand.
Are you familiar with the Bay Area's permit denial criteria?
Objection asked and answered.
You can answer it if you have that information, Doctor.
I don't know which criteria that you're talking about, so I can't give you a complete answer.
So let me go ahead and try to narrow that down. Do you recall the Bay Area's permit denial criteria with respect to overburdened communities?
No, I don't.
You agree that petitioner's rule does not allow an applicant to use control technology, to achieve the proposed 5 and 1 million cancer risk denial criteria, correct?
Objection asked and answered.
If you can answer the question, go ahead, Doctor.
Not in the way that it's asked, no.
Can you repeat that? I'm sorry, not in the way that it's what, sorry?
Not in the way that it's asked.
Rephrase your question, Mr. Calderon. I didn't understand it either.
Okay, that the petitioner's rule does not allow an applicant to use control technology to achieve or to reach the proposed 5 in 1 million cancer risk denial criteria, correct?
No, I disagree with that. It's the same language that Mr. Domenici was talking about in subpart B2. So it's, the assumption is that it's controlled emissions from the facility, and that the essence of this was, in an unmitigated fashion, is it going to get to the overburdened community? So I read B1 in the application denial as, show me the mitigated emissions.
To be clear though, the word mitigated does not appear in the denial criteria in 2011-72-12 B1 of petitioner's December 1st, 2023 proposal. Is that correct?
Objection, asked and answered.
Sustained. This is repetition.
I don't think anyone's asked whether the word mitigated is in that paragraph, but
Objection sustained.
if UNM Hospital was exempt from petitioner's proposed rule, isn't it true that its existing sources would continue to be regulated by current permit conditions?
If they were
Objection, Dr. Clark isn't a regulator.
Overruled.
You may
I
answer.
would assume that if they were, I don't know why they would be exempted, but if they were exempted, yes, they would, their emissions would be regulated under current, the current system.
You're aware that UNM Hospital is New Mexico's only level 1 trauma center, are you? Aren't you?
Objection beyond the scope of direct.
Overruled.
I heard you say that the other day, yes.
And you are aware that nearly 1 million patient visits are made to UNM Hospital each year, aren't you?
You just informed me of that.
And you are aware that UNM has the only academic medical center in New Mexico.
You just informed me of that.
And you are aware that UNM is home to the only NCI designated comprehensive cancer center in New Mexico?
Mr. Hearing Officer, I object to this line of questioning. Mr. Calderon is testifying.
I'm going to sustain the objection. I think you've made your point.
Well, this goes to the
Are you
credibility of the witness and the opinions that are provided within the written testimony.
how much longer is your list?
2 more.
Okay, go ahead.
You may answer.
Are you aware?
I am aware now.
And you are aware that UNM's Children's Hospital is the only dedicated children's hospital in New Mexico, correct?
You've just informed me.
So is that why your sworn testimony is that UNM health facilities just provide healthcare?
Well, it's a
Same
definition.
objection.
It's just sustained. I'm going to sustain the objection.
Thank you, sir.
Thank you.
Department of Energy wants to go next, or net and Tess? Mr. Harris? No repetition, please. Thank you.
Can you hear me?
Yes.
Thank you. Dr. Clark, are you okay? Do you need a break?
Actually, can I get one quick break? I need 2 minutes.
Sure.
It takes a lot out of me.
2.5 minute break.
Ready when you are. Thank you.
Thank you, Dr. Clark, for being quick.
Minute and a half.
Okay, that's great. Ms. Harris, you may commence.
Thank you, Mr. Hearing Officer. Dr. Clark, my name is Stan Harris, and I represent INTES in this proceeding. I'm going to refer you to your direct testimony, and it's the one that I'm looking at is Exhibit 180. As I understand it, the page numbers that I'm going to be providing have not changed, or the testimony has not changed between Exhibit 180 and 200, but you can tell me differently.
Okay.
I'm going to direct you to page 6.
Yes.
At the bottom of page 6, the very last sentence, I'm going to read for you. Quote, whether one looks at objective measures of public health, violations of federal air quality standards, such as the Clean Air Act, CAA, close paren, increased potential for cancer risk from exposure to chemicals, disproportionate health impacts in the form of elevated ER hospital admission rates or asthma prevalence, close paren, or social measures of health, it is clear that Bernalillo County needs to change the method in which sources of pollutants are permitted, such that public health and welfare are protected and contamination burdens are distributed, such that the most vulnerable communities do not have to continue to have the most environmental hazard exposures. Did I read that correctly?
Yes.
And that's your opinion?
Yes.
Have you specifically analyzed whether residents of any particular neighborhood or census block have been harmed by air emissions permitted by EHD?
I have looked at the results from the EJ screen. I have not taken that next step to look at the EHD permitting for any particular area.
When you say in this sentence that I just read to you, that it is clear that Bernalillo County needs to change because of the measures that you have listed in the sentence. With regard to objective measures of public health, violations of federal air quality statistics. What violations are you referring to?
This was a general statement about that. I'm not citing to a specific federal violation, other than the whole of Bernalillo County is in excess of the air quality standard for ozone.
So there are no specific violations that you can point to or have pointed to in support of that opinion.
Beyond the fact that it's a non-attainment for ozone.
Did you conduct any Bernalillo County or city specific research in support of that opinion?
No.
With regard to your statement that there's an increased potential for cancer risk from exposure to chemicals in that same opinion, what chemicals were you referring to?
I wasn't tying it to a specific chemical. I was again, I've said this frequently through this testimony, that was relating to the stationary source emissions and the quantification of risk from EPA that was generated in air tox screen. If we can dial into that even further, or we could in an analysis of this, but I was taking a higher level view of looking at the increased cancer risk or hazard index in any particular area.
So this opinion regarding chemicals, there's no specific chemical that you're actually referring to. Is that correct?
Right. I am not tying it to one specific chemical.
What media are you referring to when you say that there's an increased potential for cancer risk from exposure to chemicals?
What do you mean by what media?
Is it through air? Is it through water? Is it otherwise?
The assumption is this is through air, because the air tox screen was looking at air evaluations, stationary emissions from stationary sources.
When you say in this opinion that there are disproportionate impacts, in the form of several things, which I'll ask you about, have you studied what disproportionate health impacts you are talking about in this opinion?
You lost me on that question.
Okay, that's fair. So there's you say that there are disproportionate health impacts as a result of not doing things, correct?
Correct. And reviewing the county's data, health data related to admissions, hospital admissions and asthma rates is essentially what helped me formulate that opinion along the way.
Exactly. I apologize. Did you finish your question or finish your answer?
Yes.
What health data did you?
I believe it was, I think they call it ISIS. There's, or the local CDC has its prevalence rates that it publishes.
It is, and that's the extent of the Bernalillo County or city specific research that you conducted for that specific opinion?
That was, yes, that was part of it. And the other part is my general, looking at the available literature related to EJ and to disproportionate exposure or health outcomes from exposure to air contaminants. So it's a general view of it. And then as I started to look within the EJ data, there's some information related to the other social determinants. And I found that the IBIS system had data specific to Bernalillo County.
So the general literature that you looked at did not have New Mexico specific information. Is that correct?
Correct. But the IBIS system, IBIS, has county-specific information.
And do you recall exactly what that information was, that county-specific information?
There was a wide variety of information. I focused on asthma rates and hospital admissions for ER admissions. And it appeared that from my read of the data, that there were higher rates in certain areas.
In your opinion, you also say that there are social measures of health is one of the things that it's one of the metrics, I guess, that you looked at to say that this is a good rule. Is that correct?
Correct.
Okay. And what analysis have you done to establish that measures of health are caused by existing air emissions permitted by the Environmental Health Department?
I have not done that analysis. This is a generalized view of the relationship between development of adverse health outcomes and concentrations of those materials in the environment and communities. It's well understood in the literature that social determinants, I'm blanking on the doctor from Berkeley gave a great explanation about how those social determinants have an impact on health outcomes. So this is coupling together with that idea.
So you haven't conducted any analysis regarding social determinants of health?
Beyond a cursory review of some of the information that's there, no, I have not set up a multivariate analysis to look at what was going on there.
So you're not an expert on you're not an expert on social determinants of health. Is that fair to say?
That would be fair to say.
Okay. So giving an opinion on social determinants of health so you aren't in a position to give an expert opinion regarding the social determinants of health, correct?
Not the specifics. Through my training and experience over the last 30 years, I understand that these do have an impact. I haven't attempted to quantify what those impacts are, but I understand from reading long reads of the literature that these can have a significant impact on health.
And again, the literature that you've reviewed, the literature that you've just referred to is not New Mexico. Is it New Mexico specific?
I can't say if it's New Mexico specific or not. I mean, I don't recall a specific study looking at social determinants in New Mexico.
So just to clarify, is it Bernalillo County specific?
Again, I can't tell you if it is or it is not.
Is it the city of Albuquerque specific?
Same answer.
Thank you. Is it your testimony? Was it your testimony at both yesterday and today that applicants should be required to speciate volatile organic compounds, VOCs?
Yes.
Can you point to a list of VOCs?
I can't give you a list. It's well understood by the consultants that work for you what VOCs are. There's a definition related to the ability of the compound to move from one media into the vapor phase. So that's essentially a volatile organic compound. I'm sure there's a definition out there. Yes. So I can't give you a specific list. I can't recall off the top of my head a specific list.
Do you know how many VOCs exist?
There are a number of VOCs out there. I can't give you a specific number.
Is it possible that it would be over 10,000?
It could be. Your clients understand what the sources are. They understand what they're putting into a process, and they need to understand what they're putting out. That's all we're asking for in this. Speciate what's coming out. There are a number of methods that can be used to identify those compounds, whether it is something like US EPA method 8260, or to do an 8015 to analyze the hydrocarbon chains. It's readily available out there. This is not a burdensome task.
Well, I apologize. What is readily available? You just told me that it's possible that there's over 10,000 VOCs. And you also
Yes.
told me that there is no list of VOCs. So what is readily available? What can an applicant do to speciate VOCs?
They can do a literature review, looking at what the source material is, what has been analyzed in the past, and use that as the basis of their speciation. Or if they already have an existing process in place, go ahead and do a stat test. Tell us what's in there. All this rule is asking for is to remove the vagueness, identify what you are releasing from each source, and identify the health impacts that will have in the community.
So speciating from, so I just want to make sure that I understand. Speciating, you believe it's reasonable to require an applicant to speciate volatile organic compounds, over 10,000 of which may exist and for which there is no list. Is that correct?
Yes.
Okay.
Yes.
Thank you. Have you specifically analyzed whether residents of any particular neighborhood or census block have been harmed by air emissions permitted by EHD?
I think this has been asked and answered.
It's a different question. I can read back the other question if you'd like.
Go ahead.
Would you like me to read the question I just asked you? I will. Have you specifically analyzed whether residents of any particular neighborhood or census block have been harmed by air emissions permitted by EHD?
That data, it does not exist on the EHD level. So I'm relying on the the EJ screen data evaluation, which comes from AirTalks. So all of the permitted facilities or permitted operations are not compiled in a usable format to do this evaluation. So the short answer is no, I haven't done that evaluation yet.
Thank you. This is a different question again. Have you specifically analyzed whether residents of any particular neighborhood or census block have been disproportionately harmed by air emissions permitted by EHD?
Same answer.
And the answer is no.
Correct.
Have you analyzed whether EHD requires air permittees to comply with any standards applicable to CAPS and HAPS?
I have not done that analysis yet.
Are you aware of any air agency in any state that uses non-air factors in evaluating air permit decisions?
I'm not aware of other agencies taking this into consideration in this manner.
The use of EJ screen, are you aware that there are limitations on its use? That EPA publishes limitation, an explicit limitation.
Objection asked and answered. He covered this in Mr. Rose's testimony, I believe.
Sustained.
Cross-examined.
I'm going to sustain the objection.
You're not an economist, are you?
No, sir.
Sorry, just going through my questions. Oh, have you ever asked the EHD or the city's air quality program if using EJ screen data for HEI permitting decisions? Have you asked for their opinion regarding using EJ screen?
No, I haven't.
Have you ever had any conversation with the air permit program regarding the rule that you are propounding or in favor of currently?
No, I have not had a direct conversation with them. You know, actually, sir, you know, there was that one meeting that we're not supposed to talk about, that EHD was there, but there wasn't a direct, I'm sorry, I'm not trying to be funny. I'm just trying to be honest. There was a banter back and forth, but there's been no specific conversation between myself and them.
Thank you. Thank you for that clarification. Does the HEI process in the rule include a timeline for permit issuance or denial?
See a timeline on noticing public hearing. No, I don't believe there's a timeline on that.
Are you aware that no dedicated installation activities can commence until a construction permit is issued?
Say that again?
Are you aware? Sure. Are you aware that no dedicated installation activities can commence until a construction permit is issued?
That sounds like a reasonable requirement.
And are you, I assume you're aware that the rule as proposed, that under the rule as proposed, businesses must obtain an HEI permit before the standard construction permit process can begin. Is that correct?
I'm unclear about that. So I was under the impression this could be done concurrently.
I'd like you to turn to page 4 of Exhibit 2 of Doc 180. Again, it's your testimony.
Like testimony. Okay. Page 4?
Page 4.
Yes.
Very last line. I'll read it for you and then ask you a question.
Yes.
The line is, quote, "The system created herein by the proposed HEI regulation will allow for economic growth in Bernalillo County without sacrificing the health of the communities immediately within a mile of the new and/or modified sources, end quote. Did I read that correctly?
Yes,
And that's your opinion?
yes. It provides clear guidance, a metric for applicants to come in and say, I want to put this type of process in. And the intent is that we're not going to restrict this or make decisions that would sacrifice something that could be done in a meaningful manner. And as long as they can get control of the emissions. So putting in a new process and making sure that that new process doesn't add an extra burden to the community, rather than just lay it on the line as if you violate this, you're never going to be able to put it in. We're trying to find a way to split the baby.
When you say split the baby, is that why you're saying that this new process will allow for economic growth in Bernalillo County?
Yes, what it's saying is rather than continuing to put new sources into the already impacted areas, it would allow for, it would provide an opportunity for applicants to say, I don't need to put it in this community. Why don't I put it up here where there's more land and a different set of people? So rather than concentrating all of this in one particular area, the intent is to distribute the burden across the county.
You're not an economist, correct?
That's correct.
You have no expertise in economics, correct?
Other than running my own business for the last 25 years.
So when you gave the opinion that this rule will allow for economic growth in Bernalillo County, you actually don't have any expert support for that opinion, correct?
Other than my own experience over the last 30 years. So
Okay,
I'm not a trained economist. I'm not making that statement based on that factor along the way.
Is everything okay?
Yeah, that's fine. I'm sorry. My watch tends to tell me when my heart rate goes up that I need to. Sorry, it's the beauty of technology.
Sorry about that.
Mine did.
So it is, it's a generalized view. I'm not making a specific opinion as an economics expert.
Okay, and I just want to put a fine point on this. This is an opinion that you've given in an expert report, but there is no support for that part of the opinion. When you say that this regulation will allow for economic growth in Bernalillo County, that is an opinion that is unsupported by your expertise, correct?
I guess you could say that I'm basing it on logic, which is it's not saying there's never going to be any more new sources in Bernalillo County. They just have to be moved around. So it's a logical extension.
But not one that you are actually giving or have an expert basis for, correct?
I'm not making it as an expert basis, no.
Thank you. That's all I have.
Thank you.
Ms. Richards, do you have any examination? Again, don't be repetitive. It goes for all parties. Slow down.
Try my very, very best.
Turn the microphone down so we can hear you. There.
Can you hear me okay? Do I need to get closer or is that good? Let's give it a try. Okay. I'm going to try very carefully to not be repetitive. However, I do have to build foundation on a few questions that were previously asked. I'm also going
before you do that, I'm sorry, can I take one quick break?
Absolutely.
Take
3 minutes or 4,
Okay.
whatever you need.
So I won't trip on the stairs. Thank you.
Yeah, go ahead.
Walk slowly, please.
We'll stretch for a couple of minutes.
Thank you. I'm back.
All right, we'll continue.
So I apologize, I can't, this is a lot.
You have a copy, right? You got it from the court.
You're welcome to ask.
I'm sorry, we're waiting for the board to be ready. I'll wait for just a few more minutes.
All right, Ms. Richards, you may examine.
Sorry, I'll just need to grab a pen. So Dr. Clark, I'm hoping to ask some questions that potentially could be answered yes or no. So maybe we can streamline and move this forward. My first question is, I'm sorry, I'm just hearing the talking and it was distracting. Are you personally aware of any state or locality that solely uses the general EPA environmental justice screening tool in lieu of a state-specific tool?
No, I'm not aware of other states beyond California having a state-specific tool.
Then isn't it also true that you are proposing a method of environmental justice screening that has not yet been accepted in the environmental justice scientific community?
No.
Objection, actually motion to strike because Dr. Clark never professed to be an expert in environmental justice.
Overruled. He's answered.
You can answer the question, Dr. Clark.
I think he
I already
did.
did.
I didn't hear the answer, sir.
No.
So the answer to the question I posed, the most recent one that Mr. Jans objected to, I'm not sure you answered that question. So my question was, isn't it true that you are proposing a method that has not been accepted in the scientific community for environmental justice? Yes or no?
That would be no. EPA is a leader in environmental justice. So their promulgation, or not promulgation, their development of this tool and publication of it is generally accepted.
So despite the fact that no state and no locality has solely used the EJ tool, you still think it is accepted within the scientific community to do so?
Objection asked and answered.
Sustained.
I'm sorry, Your Honor, it was not answered. He went back to the first question and he devolved to answering a question that I did not pose to him. I'd like my question answered
I
this time.
sustained the objection.
In regrouping a little bit, is it fair to say that you were the primary author of the rules submitted under the petition for rulemaking in this proceeding?
I was the primary technical expert deriving how this could start out. Yes.
Would it also be fair to say that you were the primary and technical expert in most of the revisions?
Yes. Except for the components related to the other experts I've talked to. I believe there's an economist who's going to follow me who may talk about any of the issues related to that.
But not related to the economic impacts, the actual technical aspects of the rule. You are the primary technical author.
I am a public health specialist who was focusing on how to derive a regulation which would focus on the public health impacts rather than the standard approach, which has resulted in areas within Bernalillo County having higher rates of cancer risk or hazard index associated with emissions from stationary sources.
So then the answer to my question is yes. Is that correct?
Yes.
In your opinion, who are stakeholders in a rulemaking proceeding?
Objection. Dr. Clark is a public health professional, not the agency.
Hearing officer Sanchez, if I may, can I
ahead.
interrupt the proceeding really quickly?
Yes, go ahead.
I'd like to the board to consider a motion. There are some really important questions, and I really appreciate all the council's work here today. But I do feel like we're getting a lot of repetition, and also I feel like we're getting a lot of a lack of speed compared to recent hearings that we've been through. So I wonder if the board would consider a motion to have some time limits imposed by the hearing officer on some of this, just because I'm hearing a lot of things that I have already read in the record repeated over and over again. So that is my thought for the board to consider. Is this an appropriate time to have a discussion on this matter?
Well, I know that Dr. Clark is an important witness, and it's important to complete cross-examination. With future witnesses, if we're going to be placing a limit, the limit's going to apply to both direct examination and cross-examination. So if, for example, Mr. Pasiniak with his witness this afternoon, if he takes 1 hour on direct, I'm going to restrict 1 hour for cross-examination, and it'll be a portion between the business entities, UNM, and the labs. So you all can consider that during the lunch hour. But if it does come down to limiting time, that's going to be my proposal. You also need to understand that I would expect the closing arguments are probably pretty important to the parties and to the attorneys. If we reach a point where we're time constrained, I think the rule says that I may allow closing statements. If we're time constrained, there will not be any closing statements. We will proceed straight to deliberation.
Mr. Hearing Officer, if I might, for clarification on time limits that you proposed, just recognize that the direct testimony has already been submitted in writing, and that your direction to the parties was to summarize that direct, so that the time to summarize should not be equated with the necessary time to cross-examine. And I think by limiting it the way you're proposing would artificially limit our ability to examine witnesses before this board, and at least in my opinion, would violate the statute's direction that the board allow for examination of parties in a rulemaking proceeding.
Yes, and that's why I prefer not to limit, but we need to understand that the witnesses should summarize the testimony from their NOIs and of course avoid repetition and duplication. So
Hearing officer, I just wanted to note that we addressed these issues at length during the pre-hearing conference, and it was agreed that we would all have an equal and meaningful opportunity to engage in the process.
Yes.
And then yesterday, when the petitioners began, instead of paraphrasing their testimony, they went at length going through diagrams and pictures and exhibits. We discussed the limitations on both closings and cross-examination fully and fairly to ensure meaningful engagement by all the parties. But now halfway through, you're seeking to limit our time to put on our cases in chief and to do our cross-examination.
I just urge no repetition, duplication, let's push forward. Mr. Pasiniak's going to have some limitations on his witnesses this afternoon, so you all need to be mindful of that. I'm not a miracle worker, so let's continue.
So the question that was on the table.
Hold on a second. I think Vice Chair Richards has a comment.
Hi, I'm just wondering in terms of, and I can't recall because it's been a very long few days. I know you're saying there was a summary, you had requested a summary of direct testimony, correct? And I mean, we went through many hours of direct testimony yesterday. And then it sounds like now you're looking also at summarizing cross. I just want to make sure I'm understanding what your recommendation
You're saying limiting cross?
Limiting cross, okay.
Right.
And what's the proposal on the table? I didn't quite get that.
I'm just going to ask the parties during the lunch hour whether or not they would consider some kind of limitation, matching limitation from direct and cross. So let's see if y'all can talk about that during the lunch hour. Otherwise, if the board does move to, I'm acting at the direction of the board. I'm a neutral party. I'm here to conduct this hearing, but I'm at the direction of the board. So please see if you can discuss that amongst yourselves and come to an agreement. Otherwise, we'll see how it pans out.
Can I just ask one other clarifying question?
Yes.
So what I'm finding is going through, taking so much time, I feel like there is some repetition that could be eliminated. I'm keeping track of all the categories of questions that people have asked. There were several questions about mitigated and unmitigated emissions. And that was one of those areas where it was very repetitive. So again, I think just that repetitive thing is really, really important because I tend to like, okay, we've gone through this.
All right.
And
My opinion.
Yeah, I think the parties are attempting to do that. However, I would note that this particular testimony has been extremely disjointed because it was started and stopped. The panel system did not work for this particular testimony. Poor Dr. Billsback has been up there for hours without being asked anything. So I think the panel isn't really working in this rulemaking. And I think it's made it hard for people to go back and forth and back and forth. Remember, sometimes we have to ask a question for a foundation before we can ask the next question, which may be repetitive. I think everyone's doing the best they can. I certainly have several questions and I'm trying to be very careful to not be repetitive. I might have to ask one or two for foundation though. I only have 2 pages of questions. So.
Okay, proceed.
The question that was on the table that was objected to by Mr. Jantz was my question that was, in your opinion, having engaged in rulemaking processes, who would be a stakeholder to a process such as this?
Again, Mr. Hearing Officer, I have to object to this. Dr. Clerk is a toxicologist, environmental science, and air modeler, not an expert in public outreach.
If you can answer the question, Dr. Clark, go ahead.
The stakeholders in this would be, from my understanding, would be the citizens in Bernalillo County, the Environmental Health Department, the applicants, and any other interested party along the way.
Thank you. Now, I believe you stated in response, oh, and I'll just clarify. I'm not asking you anything about your written direct questions here. I'm only asking questions and follow up to the cross-examination that's occurred. So that might help you to streamline where we're going. You stated in response to Mr. Domenici's question that it is, and I quote, generally accepted to look at all conditions out there. Do you recall that?
No, I don't. What was the specific question that you're referring to?
He was asking you about environmental factors and social determinants of health, and you had responded it was generally accepted in the scientific community, from what I understood, to look at all conditions out there. Does that refresh your recollection?
No, it doesn't. So-
Objection. Mr. Domenici asked this question. Ms. Richards conceded that.
I'm asking the foundation for the next question, as I
Okay,
indicated.
go ahead. Go ahead.
No, I believe you've said that you did make reasonable assumptions in drafting the technical aspects of this rule. Is that correct?
Yes, I find them reasonable.
Would you assert that your assumptions drafted in this rule are reasonable if they had not yet been accepted by the scientific community?
You'd have to give me a specific example of that. You know, the assumptions that were inherent in this analysis were that a good measure, a best measure for assessing multiple emission sources, you know, new permitted sources through the community, throughout Bernalillo County, is to use this risk paradigm. And this risk paradigm has been used for decades by federal and state agencies to determine health impacts. So rather than using a standard mass rate threshold value, to look at what the health impacts are by taking the mass rate and essentially modeling where it's being distributed within the community and what the potential health impacts are.
So Dr. Clark, I'm going to ask if you could really try to carefully listen to my question so we can get through this as fast as possible. So my question was more narrowly tailored than that. You stated that you've provided different assumptions, and my question was various assumptions. My question was, if those assumptions have not yet been accepted by the scientific community, are they in fact reasonable?
Which assumptions, Mr. Hearing Officer?
The assumptions that he has used in his technical development of the rule.
Asked and answered.
Go ahead and answer.
The assumptions I used were reasonable and generally accepted in the scientific community.
So your testimony is now that every single assumption you have used has been accepted by the scientific community, because that's different than what you said before.
You know, Ms. Richardson, you need to point me to the specifics of this. You're asking me to recall something from early on. The assumptions that were included in my analysis are that they're pretty simple. There's a source. The source emits something. Each compound has some kind of associated health effect with it. All we're asking for is an analysis of what the impacts are by assessing the cancer risk and the hazard index associated with it. This is well accepted in the scientific community. There's lots of literature related to that. Most of that literature comes from the federal government, from EPA. It's used but not only by US EPA, but it's used by other agencies to assess the impacts in multiple media.
And hearing officer, I would have to ask, could you please direct Dr. Clark to limit his responses to my questions? I don't want this to go on for an hour. I only have about 8 questions.
If you can answer the question with a yes, no, doctor, please do so.
Yes, sir.
If it calls for a yes, no answer.
Do you recall stating earlier that hours of operation are not considered as mitigations under your theory?
Yes.
So then, if a mitigation if a proposed mitigation included limitation of hours of operation, that would not be sufficient under your rulemaking scheme, would it?
Actually, it would. If the proponent is willing to mitigate by shutting their facility down for a longer period of time to make sure that the total emission amount will be such that there's not a health impact, that would be an acceptable mitigation. procedure.
So then reducing the number of hours could be considered an appropriate mitigation, correct?
Sure, if you limit it to 1 hour a month to make sure that you're not impacting somebody, that's great. The goal of the rule, we always have to keep this in mind. The goal of the rule is to minimize the health impacts within the communities.
In drafting the technical aspects of this rule, did you consult with any applicants, proposed applicants?
No.
Did you consult with any federal entities?
No.
Are you
I
aware?
use the guidance from,
Dr. Clark, I
Federal
think
agent-
the answer was no.
yes,
Okay, you can stop right there. Thanks.
Are you aware as to whether petitioners or their counsel consulted with federal entities after you provided your first draft of this rule?
I am not aware.
Did you consult with anyone from Sandia National Laboratories when drafting the initial rule?
Objection asked and answered. She asked about federal entities.
Sustained.
Sandia National Laboratory is not a federal entity. NTES is a corporation.
Okay, go ahead and answer the question then.
No.
In fact, did you discuss or engage any of the stakeholders that you envision would be impacted when you drafted the technical aspects of this rule?
No, this was a proposal.
And in the different versions of the rule that you've provided, I guess, technical changes to, was there discussion about your ability to fully reject any proposals by other stakeholders?
I don't believe there was a discussion about me personally rejecting their proposals.
But together with petitioners or their attorneys and you as the expert, what I'm wondering is, were the discussions about, well, they proposed this, we don't have to accept it. What are your thoughts, Dr. Clark?
I was asked, what are my thoughts about a proposal? Yes.
To implement this rule, can you identify the types of employees the Environmental Health Department will need to employ to review an assessment, a HIA assessment?
They would need an environmental scientist who was, they already have them, capable of reviewing air dispersion modeling. They would need somebody with basic knowledge of statistics to be able to assess the relative values associated with that. And somebody who is already experienced with permitting.
Would they need somebody experienced in public health?
That would be helpful, yes. If they don't have anybody in particular, then the county also has a public health agency that they could certainly cooperatively work with.